Alrighty, thank you so much for joining us today on November 6th for our Lunch and Learn as we introduce you to one of our community partners, Atlanta Volunteer Lawyers Foundation, as they will introduce to you their services, just give you a brief overview of all the services that they have. But today we'll be focusing on two types of services that they provide for individuals who are dealing with landlord disputes and evictions, as well as an area that works with individual women. Well, I'll say survivors because men are survivors as well of domestic violence, as they assist them with their legal remedies as well as housing programs and other assistance for individuals impacted by domestic violence. Thank you so very much for joining us, Christan and Courtney, from Atlanta Volunteer Lawyers Foundation, to share with us your services, to help us be connected with what's out in the community as well. So from this time, we'll go ahead and hear from Kristen, and she's going to tell us about the program, and then we will slide into Courtney's presentation, who will tell us more about the programs for individuals who are impacted by domestic violence. We will ask that you all hold any questions until the end of each presentation. So once Kristen has hers, we'll do some questions, and then we'll do the second part. But in the meantime, if you have questions, if you're like me and you tend to forget your question, feel free to drop them in the chat, and we will make sure we get those as well. I am Walisha Wilson Menifee, the founder of New Life Second Chance Outreach. Started this program in 2012, shortly after I got out of prison, to connect other individuals who were impacted by a criminal record with resources that are open to individuals with criminal records. And so we thank you all so much for joining us. And whenever you are able to, please join us for our upcoming events that we have going on next week. We will have Feeding Georgia Families here to talk to us about their services that include free groceries, utility assistance, rental assistance, and their food pantry. So please make sure that you register for those events as we try to connect you to holiday some help for the holidays. And this is our next week is our last community lunch and learn until 2026, where we'll be connecting with new partners for them to share their information. I just dropped that link in the chat as well. So thank you all so much for joining us, and we'll turn it over to Kristen.
Hi, everyone. I am Kristen from Atlanta Volunteer Lawyers Foundation, and I work specifically with the Access to Counsel pilot team. I'm going to start sharing my screen. Hopefully you all can see it okay. Because the first few slides, I just kind of break down what Atlanta Volunteer Lawyers Foundation does and what our specific team does. So as you can see here, AVLF is a nonprofit, and we are here to help those who may need some extra assistance with standing up to all of these systems that do make it very difficult to navigate. And our main objectives here are eviction defense, landlord-tenant disputes such as your security deposit, repairs and condition issues, discrepancies in your balance, your ledger, something like that. And then, of course, we also have our family side, which does intimate partner abuse advocacy, and specifically has a family law program, which is what Courtney will be speaking to you about after my presentation. So this is the pilot team for who I work. Crystal Red is our director. Katie Hearing is the managing attorney. I'm the paralegal on the team. Kelsey Matthews is the eviction outreach and engagement specialist. So between between Kelsey and myself, we do canvassing and we do the intake calls, that we are the first line of defense when someone reaches out about eviction defense, and I'll go into a web, so she will also be helping with cases as well. So the pilot team specifically, like I said, does assist with eviction defense for those who are either already facing an eviction that's been filed, or those who are being threatened with an eviction. And so we do also have partnerships with the City of Atlanta, the Housing Help Center, Housing Justice League, and then in general, just being in the community, AVLF is aware of very many resources. And so we try to make sure our clients also receive any resources that we may have access to or have information about, because of course we know this is all intersecting. Your housing is the most important thing, but it can be affected by or can affect your job and all of the other things, especially when there are families, and most of our clients are parents. So this is the specific map of what my specific team does. We do assist with eviction throughout Fulton County. However, the team I'm on, what the city did is they hired someone to pull in data and see where the highest evictions were being filed throughout Fulton County. And this map shows where those were. And so that is where we have concentrated our initial efforts. When we say pilot, it is literally a pilot program here in Georgia to show that anyone should have access to an attorney if they're facing eviction. The same way the idea is that you should have access to an attorney if you're facing some type of criminal charge. We're trying to show in Georgia that should be the case as well. They are doing it in other states. New York, Connecticut has already done so. Los Angeles and their county has already started implementing it. So it's been done elsewhere, and we are working with some of the same consultants who help those states. So we're hoping that we can get it implemented here in Georgia. And we are starting with these areas, but we will be expanding, especially to try to connect the 285 and Camilton cluster and that English Avenue 285 gap that you see there. Okay, so I just want to reiterate, I'm not an attorney. I have been doing this for a while, so I do know some of the answers, but I cannot give you complete legal advice. But I will say what I have seen and what I understand here in Georgia. Grounds for eviction are not paying your rent, not moving out after your lease is expired or is terminated due to some reason. And so that would be considered a holdover, and then violating your lease term or condition or conditions. So the eviction process goes like this. Of course, this is a very simple condensed version, but the idea is that a landlord is supposed to demand possession first. It should be in writing. However, it does not have to be. It just really for them is more covering them. And then after that, after they have given this demand, the idea is that they are supposed to file a dispossessory warrant. And I'll show you what that looks like on the next page if you're not familiar with the court. And then once someone is served with that same dispossessory warrant, they have 7 days from the date of service. And the difference, the only caveat I will say, or the only exception is if that date to answer falls on a Sunday or a weekend, I should say, or a holiday. So that does change it a little bit. And then if they do not answer within those 7 days, what happens is they are found in default. They may still get a hearing date, but it'll be a judgment on the pleadings. I have actually gone into the courthouse and witnessed this. The judge will ask everyone to stand once they call the name and tell them, unfortunately, even if you did file an answer and it gave, which I'll go into that in a second, your answer filed but didn't have as good enough reason, quote unquote, good enough reason, or you failed to file an answer, you're now your home is now in the possession of the landlord, and you have 7 days to either work out an agreement with them or leave the property. And there, I can go into more detail about what that 7-day period is like. So the thing about the answer, if someone says, I just did not have the money, or I will have it in a few days, something like that, unfortunately, in this state is not merit for avoiding an eviction. It's automatically going to go into that category that I was just talking about, the judgment on the pleadings, where a judge will say, unfortunately, that is not a valid reason in the eyes of the law for you to stay in your home. And so, unfortunately, now the landlord does get possession of the home. If you do file an answer and you give a reason, this isn't my landlord, and I'll show you the form in a second. This isn't my landlord, or they haven't fixed these conditions, or the ledger is inaccurate, or something to that effect. Then you'll get a hearing date or a mediation date. They are really pushing mediation now. So a hearing would be sit with either the landlord or the landlord's attorney and try to negotiate negotiate what you all may want to work out or present evidence to the judge. Alternatively, if you're given a mediation notice, then you would do the same thing, but in a more private setting. It would be to the side in a room. And the mediator is supposed to be an unbiased third party that is just there to make sure that the parties are coming to or being fair and ideally do come to some type of agreement. So I did kind of just go over this, but this just breaks it down a little further that the landlord does have to state go and file an eviction. And as I said, it doesn't have to be in writing unless the basis for the eviction would be non-payment. And if it is a non-payment situation, the demand must be must be in writing and give the tenant 3 days to submit payment or cure. And that was due to a recent law that some of our AVLF staff was helpful in implementing and getting put on the books. So this is the warrant that I discussed. Of course, this is a blank one, but usually if it's a matter of non-payment, right there at part 3, they would check that first one, fails to pay the rent, which is now past due, and then notes exactly how much it is down in part 5. And it should break it down by month, the amount, and then in part D down there, they would list like attorney fees, or if you're paying your landlord for water or something to that effect. It's usually listed there. And so this is what would either be tacked on the door or put in the mailbox or served personally on someone. The person that is being served needs to be 18 or older. Also, a lot of times, and so I don't want to necessarily get into a whole bunch of nitty gritty because I don't want to cut into Courtney's time, but it's very important that the person serving understands who's how old the person is if someone is answering the door and whether or not that is someone who can accept that on their behalf. And so, as I said, they do have the 7 days to respond. To file an answer, it can be filed online, but there is a fee, or you can go into the courthouse and file. And we have a team that actually works in the courthouse, the Housing Court Assistance Center team, and they work, I can put that info in the chat too, which rooms and dates and the location and dates that they work. And so they can help file this or anything else that needs to be filed if the case has already moved on past that stage. So some examples that are listed are, as I said, my landlord failed to repair the property, or just it might just literally be I don't owe the landlord any money. Of course, we all know that that can be the case sometimes. I offered to pay rent, but the landlord didn't accept it, things of that nature. So as I said, sometimes people will state, I just unfortunately did not have the money, or whatever the case may be. And even though that is a very valid reason in my eyes, unfortunately, legally, that isn't something that a judge will accept as a reason to avoid an actual set out of the home. And then this section down here, the counterclaim, if one does have an issue with conditions in the home or something to that effect, or lost property or what have you, they would list that amount down here, what they find this amount to be reduced to, because the home is not worth what you're claiming, what the landlord is claiming. It's not in the condition to be valued at that same amount. The judge would really like to see a specific amount listed. Of course, that's not always going to be the case. We used to be able to put to be determined, but they are kind of cracking down on that. So I just want to make a note of that. And then, as I said, they will either file, I'm sorry, the tenant will get an order, a notice for mediation or a notice for hearing. And the mediation, as I said, it does usually give you more flexibility for negotiating one-on-one. It's more private. I personally feel like that makes a big difference instead of standing in front of a whole courtroom full of other people and having to plead your case. But some cases are actually put, for hearing. And then of course, some tenants would prefer a hearing because, yes, I've been dealing with all of these things and I want to show this judge all of this evidence so that we can have my counterclaims honored or whatever the case may be. The notice is supposed to be sent by mail. I will be very frank, in Atlanta, the mail obviously is kind of crazy, and there have been a lot of instances we've seen in which people are not getting those notices. The judges are aware, and the judges and clerks are aware. We've talked to them about it, and there is an ongoing conversation about how to make sure that doesn't happen. And there has been some cases in which there was a rescheduling or a whole set of cases have been rescheduled and the tenants were given some other options because that wasn't on, on their because of something they did on their end. And so I can give a little more info, but that is the end of the part that I intended to discuss. I can give you an idea of like what the trends are, or if you guys have any questions you want to ask now before we move on to the family. I'm not sure if you necessarily are okay with that, or if you wanted to wait until the end to have the
No,
questions.
we had a few questions I think pertaining to your
Okay.
presentation. One was a short one. Are the services that you just said for Atlanta only?
Yes.
Okay.
Specifically, my team is in that area that was on that map. But we do assist all of Fulton County. So I'm sorry, I shouldn't have said yes to that. It's all of Fulton County, not just the city of Atlanta. But my specific team is just in the city of Atlanta on that map.
Okay, so if someone outside of Atlanta called with their eviction issues, where would you all refer them to call?
Outside of Fulton County,
Yeah.
yes, I would say Atlanta Legal Aid is the main one that we refer them to. They have
Okay.
offices in DeKalb. They're also in the Clayton County courthouse. They have like an attorney set in there. So that's who we
What
use.
if someone is on the call that's in Columbus or
Georgia
Savannah?
Legal, Georgia Legal Services is one that we use a lot. I
Okay.
need to pull up my list because I don't remember all off the top of my head, but
Okay.
those are the ones that we normally do refer
Yeah,
to.
I just dropped their information again.
Okay,
Okay.
thank you.
Thank you.
Yeah, do you
And
want me
then
to
we,
read from the, oh, sorry, I
huh?
was just going to say, do you want me to read any questions from the chat or?
No, we had one other one. It says, how can I challenge an eviction if I moved, but they kept charging me rent like I was there, even if I gave my keys back?
Um, are they challenging the like is it on the collection? Like is it a collections? I'm sorry, I didn't go to the chat to see exactly.
Yeah, she didn't ask anything,
Um,
but you can feel free to come off
yeah, do
mute
you mind giving
if
a
you
little
would
more
like.
info? Yes, it's in collections.
It's in collections.
Yeah, okay. Um, if the key was returned, I hate to have to tell you to give all your business online, but it was were the keys returned and the
They charged me from July to October, but she moved July 1st. Ooh, that's wrong.
very wrong. I would really like to get a little more info about the keys being returned. Like, was
Okay.
there was there a dispute about that or um
So if you want, Kristen, can you drop your email and maybe she
yeah,
can just
absolutely.
contact you?
Yeah, and then
Um,
I will say the other thing is I don't know if she was the one who had mentioned it. I was kind of seeing earlier about emotion.
I didn't see anything.
Sorry, I thought I saw something about like closing or getting one sealed. But that is if the case has already been closed with the court, but there is this issue of having been charged afterwards and it's on collections, I would say contacting the previous landlord and having to correct it and remove it and or filing a motion for the case. I mean, in the case, but I don't know again what the rapport was with the landlord, if they're just lying about it was, very clear that they received the key, there's proof. Yeah, so I would say if you don't mind, can you email me, Miss Love, and I'll definitely speak to you about that further.
And was that the question you answered that says, do you help get the eviction record sealed after a client's case is dismissed for
Yes, we
Cobb
do.
County?
We
Okay.
not in Cobb, but we do assist with that. Atlanta Legal Aid does have a Cobb County office, so they can
Okay.
help us with that, I would think, yes.
Okay. And you don't have to worry about scrambling with a lot of these things unless y'all are going to be doing it probably within the next couple of hours. I will actually be sending not only this recording, but everything that we put in the chat. So it'll be in that same email for everybody who's on the call.
Thank you.
Okay. Thank you so much, Kristen. If you have any other questions, we will have a second part of a Q&A toward the end before we get off. So in the meantime, when we get ready to go into Courtney, who's moving into her part of the portion for individuals who are domestic violence survivors. If you have any other questions about the eviction stuff, just drop them in the chat, and then we'll get to that as well at the end of the Q&A. So at this point, we'll go ahead and move on to Courtney.
Thank you. Like it's been said, my name is Courtney Johnson, and I am the current interim legal director for our Safe and Stable Families project with AVLF. And so the thing with our part of the program is that most of our um, clients come from our SFO office, which is the Safe Families office inside the Fulton County Courthouse. People come there when they're looking to file a temporary protective order. And so a lot of our referrals come from that to the family law program. We also, again, staff that courthouse program there too. People can come in and get support to go ahead and file the temporary protective orders. And I do talk a little bit about that in the slides as well. So in order for you to reach me as a family law attorney or to be able to get assistance, it would be through either the courthouse or another community partner organization. There are a couple other groups that have already been mentioned that also provide free legal assistance. So Atlanta Legal Aid would be one of those. With Atlanta Legal Aid, you can either call in or apply online for their services. And then if you are in Fulton County, Cobb County, or Gwinnett, there are also courthouse clinics. And so they all run a little bit differently, but they do have attorneys there 1 to 5 days a week who can like make appointments with or answer questions or get help with forms or just general consults. So there are some couple other resources out there. Let's see. Okay. So again, this is more information about our family law program. So we assist survivors who are survivors of intimate partner abuse with their family law concerns. And when it comes to family law, we are very broad with what that means. So that can mean divorce, that can mean a custody case, that can mean child support, that can mean a name change. So we definitely try to be very open if it involves a family. More than likely we're able to assist with that in some way. What we focus on is either trying to do the best we can, like we are a small team. And so we provide consultation, so advice or self-help, maybe get a certain form to you that might be helpful. We also do have some volunteers who will represent clients and take cases, so we do support those volunteers. And then when we're able to, we also provide direct representation to clients. So these are just another couple of examples of family law cases that we take. So divorce, which is you are ending a marriage, child support, asking for the other parent to pay every month to help support the child. Legitimation, I'll talk a little bit more about that, but that is helps a father become a legal father. Name changes again, and with the name change in the state of Georgia, you are able to request a name change and really for whatever reason you want to. And you can change it to whatever you want. The only catch is that the law does state that you can't be using that to like defraud the state. And so as long as you're not trying to defraud the state, generally you're able to get a name change. And again, it can be whatever you want. If you want your name to change to Princess Sparkle Pants, like you can absolutely do that in Georgia. A modification is something that you would file to request a change in custody or child support if you already have an order for that. And then I just have a other here because there are always things that kind of come up and we may be able to assist with that. So it could be like getting a birth certificate or changing your birth certificate name if you got a name change previously. So we do try to help as much as we can. These are just some frequently FAQs, so frequently asked questions that I get. And so I just kind of wanted to go over a little bit of information. So just very general, but just so you all have some basis about what some of your rights would be when it comes to the family law, like legal space. So I will talk a little bit about divorce, about child support, about father's rights, about what you can do if you're raising a child that's not yours, and then also about filing a temporary protective order. So, in divorce, who can get divorced? It is anybody who is married. It does not matter how long you were married or where the marriage occurred. So, if you went to a different country and got married or a different state to get married, as long as you are married, you are able to get a divorce in Georgia. What you can include in your divorce is, if you have children, would be custody, child support. You can always ask for alimony. Alimony is not guaranteed in our state. It is really up to a judge, and they're supposed to look at several different factors. So that includes how long you were married, how much the other person makes, if they can, afford to pay you a certain amount to kind of help you get on your feet, that kind of thing. So it's up to a judge ultimately, but it doesn't hurt to ask if that would be helpful. It's also a division of property and debts. And so one of the things that is really important for people to know, because it's not necessarily common knowledge, is that anything that you bought or anything that you like acquired in debt in terms of like credit cards, loans, all of that is marital. So it doesn't matter whose name it is, it's in, it doesn't matter, exactly when it occurred, as long as it occurred during the marriage, it is marital property. And so we see that a lot with people, for example, who like will, get married and then they separate and they don't divorce for many, many years, but then they bought a house in between. That house is technically marital property. And so you would want to make sure in the divorce that that house stays with you because you purchased it, your spouse didn't have anything to do with it, but because it was during the marriage, it's marital property. And the same thing goes for debt. So if you are separated from your spouse and they go and they get a bunch of loans in their names and that kind of thing, that could like the creditors could try to come to you because you were married during that time. So a divorce would help to make sure that that debt does not belong to you and that creditors know they need to go to your spouse for that and not you. Where you would file is the county of your spouse, so where they live, unless you all were living together in the county that you're in for the last 6 months. So if I am, prepared to get a divorce, my spouse and I both lived in Fulton County, and they left yesterday, I can still file in Fulton County. If they left a year ago and now they live in Douglas, I have to file my divorce in Douglas. And you can find forms to file if you are filing in Fulton County at fultoncounty.org. I also put like a more direct link in the chat earlier, but the Fulton County website for the Superior Court does have quite a few forms. And so they're PDFs. You have to be able to like have access to a printer, and then you'd either have to like print them out, write in everything, and then upload them, or to use like a PDF viewer to like type in on a computer the information you need for the forms. Some other counties do have forms also available. So I know Cobb has some really good forms. Gwinnett has some good forms as well. I think Douglas has a couple of forms, but not as many. But also because we all are still the state of Georgia, if you like the way the Fulton County forms look or they're like helpful to you, you honestly can cross out Fulton and put whatever county is helpful that you're filing in. Just make sure it's all crossed out so they know what county it is correct. There is also, like I said before, a Justice Resource Center in the Fulton County Courthouse. So there, you are able to get the forms. They do charge you because they already have them printed out, so they charge you for that service. They have notaries there who will notarize documents because you do have to have things notarized before filing. And you're also able to make appointments with attorneys or like check in with attorney if there's one on staff that day to answer questions and make sure you have the right forms. It's expensive to file any kind of case. So it's often about $225, give or take. They change the amount all the time, but it's usually somewhere around that amount. But something that's really helpful to know is that every single county in Georgia has a fee waiver. So they can be called different things. Sometimes they're called a poverty affidavit. Sometimes it's called an affidavit of indigency. But either way, it will be a document. Also, it ranges how long it is. Like Fulton County, they changed theirs several years ago, and now it's like 5 or 6 pages, which to me is way too long. But in other counties, it's like 1 to 2 pages, but it'll ask you about your income, your bills, and then a judge will look over that poverty affidavit. And if they feel like you are not able to pay, then they will waive the fees. So you are able to file your case for free. Um, There's also sometimes a fee depending on what county you're in for using the internet system. Like in Fulton County, everything is filed online. So even if you go to the courthouse, they're going to have you go in front of a computer and file your case on the computer online. If you go to the courthouse, they often waive the extra fee, so you don't have to pay the fees that the website would charge you. But if you're filing it from like the library or something, that's another consideration that there may be a fee to file it. So it is not cheap to do, but if you can get that waiver, it often will waive the fees for all of the like filing services for generally for the clerk's office. In Fulton County, it also will help waive the fees if you are ordered to go to mediation. So if the judge tells you that you need to go speak with the other person, like with another party to come up with a agreement, then that'll be waived. Or if it is also possible if you don't know where your spouse is to still get a divorce. It's just a little bit different. Instead of having like a sheriff come to their house and give them a copy of the paperwork that you filed, it would be put in a legal newspaper. So it's called publication service. It's like a little advertisement that basically says, your name, their name, that a case has been filed, and then it runs in that paper for about a month. And then a month after it's done running, you're able to get a final order. So you don't have to know where the person is, but you would also have to tell a judge that like you don't have any idea, and here's why you don't have any idea. So it's been a long time, or they're in transition in terms of where they're living from place to place, that kind of thing can all be included in there. So child support is something else that's usually really important for people to know more about. So child support is basically a monthly payment that a non-custodial parent pays. So the parent that the child does not live with primarily pays to the parent who the child does live with. And when we think about what child support is for, I know people who are anti-child support love to say, well, oh, they were just getting their nails done or a new whatever. But really, like child support is important for a child to make sure that they are supported. And it could include anything. So it can include you using that money to help pay your rent or your mortgage because your child lives there and they need to have a place to live. It can include general food that you're buying for the house that your child is eating. Hygiene items, clothes, all of these things is what child support is supposed to be able to help cover. It also can include other expenses that a child has every month. So like health insurance, daycare, after school costs, if there are also just really big costs that your child has, and because they have a condition that they need certain therapies for or certain medical treatment every month, that can also be included in how much child support you receive. It's based off of the income of both parents. And so a child support worksheet is what a judge looks at to determine what child support should be. So it's basically putting in what your income is and what the other parent's income is into a calculator. Any other expenses that might apply, like I said, after school costs or health insurance costs goes in there, and then the number pops out. And that's normally kind of what the judge is going to go with. There are always exceptions to the rule. Like basically in family law, there's always an exception and always an argument that can be made. But generally, it's going to be whatever that amount is going to be kind of what child support is going to be for the month that is owed to make sure the children are taken care of. You can get child support in a couple different types of cases. So in a divorce, it can include child support. Any kind of custody case, it will include child support. Temporary protective order also can include child support. A child abandonment warrant is another way to get child support. So that's something that is filed in magistrate court. And it is a warrant and it is a criminal matter. Basically, in the state of Georgia, if you don't contribute to the well-being of your child every 30 days, you are able to file a child abandonment warrant as the parent that's taking care of that child to say the other parent has not helped me financially. When you go to court for that, the judge can give the other parent like a deadline to pay something. They can have them pay something right then and there at that court date. They also will often have them sign up for child support services to make sure that this does not happen again. Child support services, again, is another way to receive child support. With them, it is applying with their service. If you receive some state assistance, sometimes they will waive the fee because there's a $25 fee to apply with them as well, but they will waive if you've already received assistance from them. And with them, they do all the legwork. They take a little bit of time because there's a lot of people that they have to service, but they do the legwork. They will file the child support case for you. They will make sure the other person gets served with it so that they know about it. And then they can also basically be debt collectors. So they will get the money from the other person every month and then provide that to the parent that is receiving the money. And that can be through like direct deposit or like a debit card. And then if they also have some ways to encourage people to pay child support. So if someone doesn't pay, they can take away, like suspend their license. They can take tax return money if they file tax returns. And then also when you're registered with them, they help to track this in the long term. So when you have a child support order that says that someone owes child support, that stays until it's paid. And so that child could be an adult with their own children, and that person who owes the money still owes the money. And so that sometimes comes up too with people when like they're receiving like retirement benefits and those get garnished. So it's important to know that like once a child support order is in place, it is in place. And that money will just keep building up and that debt will just keep getting higher until it is paid. So again, who pays child support? It is the parent that the child does not live with full time. And again, with in Georgia, both parents have a duty to support, and that also it includes even if the parent who's paying child support has no custody or visitation rights to that child. So custody and visitation are different than having any right to actually pay for that child. I talked about the child support calculator. This is just the sample page. So the child support calculator is available to anyone to look at or to put in numbers, kind of experiment with it, print it out, provide it to court, all of that. That's all available on the website. And it's not super, super difficult to do. It is quite a bit of numbers and like different things to put in. The good thing about the child support worksheet though is that there are like asterisks by places where you have to include a number or have to include a name. So it won't let you move on unless you put certain things in there. With custody, in Georgia, there are two different types. So custody is physical, and that's who the child lives with most of the time. And legal is who makes choices for the child. A lot of times in our cases, we will narrow it down to who makes choices for the medical care for the child, for their education, for extracurricular activities, and then for religion. With custody, it can be either joint or sole. So sole is just like the child for physical lives with one person. If it or joint that the child lives with both parents. Usually when we talk about joint, that means that there's equal time. So like a child is 1 week with one parent, 1 week with the other parent. With legal, if that's going to be joint, then the parents will talk about a choice they're going to make for the child. But the catch with that is somebody has to be the tiebreaker if the parents don't agree. So it's important to also have in any kind of custody order who's going to be that tiebreaker, who's going to make the final decision for the child if the parents can't agree. Custody is determined by many factors. What a judge mostly uses is what's in the best interest of the child. And I do have a slide to show kind of some of those examples. The best interest statute is super long. And so there are, I want to say it might even go to Z, like A through Z, of like what the judge is supposed to consider when it comes to what's in the best interest of the child. And that's what really is used to the basis of to figure out where the child should live most of the time and who should make choices for the child. That's all going to be written up in a thing called a parenting plan. So that really outlines how the child's going to spend their day. So what days they're with one parent, what days they're with the other parent, how they split up holidays. It'll talk about how the child is going to be exchanged. So like where the parents will meet. Do they meet at someone's house? Do they meet like at a police station or a Chick-fil-A to do that? And then also if there needs to be conversation about how they're going to communicate. So these parents really, like you don't want to talk to the other party at all. You can use like a parenting app to do that. There are plenty of ones that are free nowadays, or if it's just like we have no contact at all unless we're talking about the child, that can also be written in this co-parenting plan. Legitimation is something too that people are not always aware of, and I'm always happy to talk about it. So if the parents are not married when the child is born, the mom has sole custody of that child, so physical and legal. The child can live with mom full time. The mom can make all the choices for the child. And in order for dad to have any rights in terms of custody or like a plan to see the child on certain days, to be able to make decisions for the child, all of that, they have to file a legitimation case. And that will make them the legal father, which means that the child also can inherit from them. Something happens, the child gets some death benefits from dad. And then it also will include an order for child support. And so this kind of also goes back to the child support piece in that a father could be ordered to pay child support. And if he has not gone through this process of legitimation, that means that he doesn't have any rights to see the child. He doesn't have any time with the child, but yet he's still being asked to pay for that child every month with child support. And this is just an example of some of the things that a judge is supposed to look at when it comes to the best interests of the child. And so like just how the child has bonded with that parent, their ability to provide for the child, and that ability to, the judge is supposed to look at if that parent were receiving support from the other. So it's not fair to just say, oh, well, parent A has like this big old house and the kid, has all the video games and, their own room and it's just like this huge mansion. And the other parent is, still working on things. They may live in a shelter. They may have, a studio apartment and not have the same amount of resources. But if the parent in the mansion was paying child support to that other parent, they would also be a different position. That's supposed to be looked at when it comes to the best interest of the child. Also, generally looking at like the home environment of the child that they would live in. So like, do they have access to, a place to sleep, a warm bed, that kind of thing is also supposed to be looked at. If you are not the parent, but you're taking care of a child, you want to make sure that they're taken, care of legally, or that you have the right to make choices for them. There are a couple different options, and it really also depends on how you know this child. So, like, is it a grandchild of yours? Is it a niece? Is it a nephew? Is it just a family friend? How do you know this child also depends on what your options are. Grandparents do have custody rights. They do have rights in general. And so grandparents can file a grandparent custody case to get custody of a child, or generally to get like some parenting, like some time with the child, kind of like a weekend plan or a holiday plan with that child. In these cases, they really have to be able to say that they had a close relationship with that grandchild. And for whatever reason, a parent stopped that. So like the child used to live with them, or they were supporting the child financially, they were involved in the child's like daily life. A child will be harmed without, being able to see this grandparent. There is an equitable caregiver statute, and so that one really it encompasses a lot more people. So it includes anyone who basically is not a parent but taking care of a child like a parent. And so I've had some cases with this where like I had one where the father found out later that the child was not his biological child, but he had treated him as such for several years and wanted to continue to take care of him. So in this case, he's a non-parent technically because he's not the bio father. but he had taken a role as a parent, and so he was able to file under this. Um, that's a helpful one. Guardianship is used in probate court, and so it doesn't even always involve a court date. Often can just be filing documents. It's better to have the consent of at least the mom, if dad's not legal dad yet, to say that they're okay with the guardianship. And a guardianship really gives the guardian all of the rights that a parent would have, but it doesn't terminate the parent's rights. But it just allows the guardian to like take the child to the doctor and make choices for them. The child would live with them. And then if the parent at some point was like, I really feel like I no longer need this shit guardianship, I can take care of my child and put them back in my home, they can also revoke it. And so that's just another document that's filed in court. If the guardian disagrees with that, then the guardian can also, argue about that and file a case saying, I want to deny this. If they do that, it's a very short turnaround, it's like 10 days. And then if they do that, then the case does go to juvenile court, and then a juvenile court judge will make a decision about where the child should be. If you have a child in your home that again is not your biological child, it's not your grandchild, or you're not the guardian of that child, but you want them to be in school, you can just fill out what's called a non-parental affidavit. And most county schools have this like in person or on their website, and just basically says every child has a right to go to school, and so this child is living with me for this period of time. I don't have custody of them legally, but put them in your school. And they're supposed to automatically, let you enroll them in school. Power of attorney is another helpful thing, and that can be used for like specific purpose, and so, or a time frame. So like maybe a parent is in the military and it's like, I want, another person to be able to take my child to the doctor and make choices for them for this time when I'm like going to be gone. Then they're absolutely able to do a power of attorney with that, and even give a deadline, like after this date it expires, and I have all, the ability to do that afterwards. And that also does not necessarily need to be filed with court. It's just filling out a paper, getting it notarized and signed, and then making sure there are multiple copies so that everyone who needs to have a copy of that knows about it and has a copy. The last thing I want to just talk about a little bit is a temporary protective order. So it is a civil order, which has the ability to tell someone else who could be harmful to you that they can't have any contact with you. So they can't come within like 2 football fields of you. If they're that close, that's too close. They can't have any contact with you in terms of phone calls, emails, social media, just nothing at all. And they also can't have anyone on their behalf get in contact with you. So they can't say, oh, I want my cousin to call and say something to this person. They can't do that either. A temporary protective order does last for 12 months. It's a little bit of a process, but at the final stage, it can last for 12 months. If within that 12-month period there are violations or a need to continue it, when you get towards the expiration date of the 12 months, you can go back to court and ask to extend it, and then it can be extended for 3 years at that point as well. And then these are also filed in the county of the other person. So in the county of the person that is causing you harm. Some of the things that a temporary protective order can include in the order is, again, a restriction for how close they can be, so that they can't be anywhere close to you, that they can't communicate with you. You can ask for any fees that it costs to file. Now, when you're filing a TPO, you can file it for free, unlike your other cases for family law. It does put them, the matter in a protective order registry. So that means that all of law enforcement can see it. So if someone were to be in violation of this order, if you called the police, they would be able to look up in their system that you have a TPO against that person. It also, even though it's civil, it does have criminal enforcement. So if someone violates it, then they can be automatically charged with aggravated assault. It's full faith and credit, which means that you can take this wherever you need to. So if you get your order in Fulton County, Georgia, but then you move to Chicago, Chicago police should still be able to look at your TPO and still enforce it. It can include that the other person who is at fault here can have to go to drug, alcohol, or psychiatric counseling. And then the things in purple are things that it also includes. So if there are children involved, it can include something about custody and visitation, so what that will look like. If there are children involved, it can include child support. It can include an award of property if that's at issue. So sometimes that will also include, like, if you all were living together, who's going to continue to live in the home. It can include support if you are married to that person. So like alimony, spousal support. There's a federal firearm prohibition. And so if there is the person who the TPO is against does have a firearm, they are supposed to hand that firearm back in for the length of the temporary protective order. It can include that the other person has to provide alternate housing if you were living together, if there was damage that occurred because of the incident. So if there was, you all were living together and something happened in the home and there are like holes in the wall or broken TVs or broken windows, then they can also be asked to pay the costs for that. Lastly, they can be asked to go to FFIP, which is a family violence protection classes. And so those last for, I want to say a year, but I could be wrong. But there are quite a few classes that people can go through to try to kind of get at the root of why they're in the situation in the first place that caused someone to get a TPO against them. There's another thing that's like a temporary protective order. Temporary protective orders, people who live together or are somehow family members or have children together. If you are just dating the other person, you can also now get a dating violence protective order. And so it doesn't include as many things, but it can include a award for any property that you have. So maybe let the other person like took your phone, for example, and you couldn't call 911, they kept it, you can ask for your phone back. And it does do the most important things in terms of like limiting how close they can be with you, that they can't communicate with you at all. And again, it does put them on a registry so all law enforcement knows that they can't have contact with you. There's also a stalking protective order. And so with this one, you would file this if there is someone who has had multiple instances of harassing you. So like multiple phone calls or they're following you around. You're also able to file a stalking protective order. And this one, again, you're limited in terms of like what you're able to get award wise, but it does limit their ability to get in contact with you at all. And that is it for me.
Well, thank you so much. That was a lot of information, but it was some great and very informative information. And I think I just want to make sure, just to make it clear, because I don't want folks to be on the call feeling like they didn't get anything out of it because they're not here. Both of the services, all the services for AVLF are for Fulton County, including what you just mentioned, Courtney, right?
So yes, we are based in Fulton County. However, like we'll do consults and like give you anything that we can help you with resource wise, even if
Yeah.
you aren't in Fulton. But in terms
Okay,
of
because
like
I
being
did
able
drop
to
in the chat
represent.
about y'all Saturday clinic and stuff like that.
Yeah,
Okay.
and I'll clarify on the housing side, we do assist in Clayton County as well, but we don't assist with eviction defense in Clayton County. So with those
Okay.
things that you mentioned, like Saturday lawyer, if you're dealing with repairs and conditions or a security deposit wasn't returned or something like that, and you're in Clayton County, we assist with that as well.
Okay. And what program is that?
The whole safe and stable housing
Mm-hmm.
side, except for the eviction defense part of it. So like what you put
Okay.
in the chat, the Saturday lawyer, those are really our two main when it comes to the housing, but yes.
Okay. So Saturday Lawyer is only for Fulton and Clayton.
Yes, exactly.
Okay. Okay. Well, thank y'all so very much. Are there any additional questions that anybody may have had for Kristen and Courtney before we go? I think oftentimes we do have lunch. A lot of times we're either playing on our phone or trying to catch up on our stories. Do they even show stories anymore? Or doing something. But this is really good to be able to have something and take a lunch break where you can actually get some very formative information. So I thank you all so much for your partnership and for joining us for this 1 hour webinar. Everybody said it was great. Again, we will make sure we upload this to our YouTube page, and I'll be following up with everyone, sending you the resources and everything that was dropped in the chat. Thank you all so much for joining us, and have a great, blessed, and safe day.
Thank you, everyone. Be safe.
Thank you.